Hello, Don Rolfe here, the owner and founder of Northwest Legal Planning, and today I am here talking about the differences between wills and trusts, and specifically when they actually do something. So if you have any questions about this or any other estate planning topic, do feel free to reach out to me. Go to myestateplanmeeting.com and you can set a meeting for me to call you, or you can come into the office and meet for a half hour absolutely free. So the difference between an estate plan with a will and a trust, and when those documents actually do something, generally something for you or for someone else. So a will, I'm going to cut right to the chase, doesn't do anything while you're alive except give you peace of mind that it exists. When the will actually does something is only after you have passed away and that will has been submitted to the probate court and has been accepted by the probate court. And then what you have put in that will actually start to do something. That's the only time that it's operative. And like I said, obviously getting a will drafted, signing it, and knowing it's in place. So during your lifetime, it is doing something. It's giving you peace of mind that you know that when you do go, that will is going to operate. It gives you peace of mind that you have put down your wishes, your desires, provided for the people that you wanted to, all of those things. You know that that is right there. It's in the drawer, on the shelf, wherever it's at, it's going to work. Conversely, a trust. A trust can do something the day after you sign it and fund it. So we put together a trust and we kind of think of it as a bucket that we carry around with us. We take all of our stuff, we put it into the trust. So our bank accounts get retitled in the trust. Our homes, all of our real property, all of our personality, our clothes and jewelry and paintings, furniture, all of that, we assign it into the trust so that it's titled into the name of the trust. So that during our lifetime, everything's in that bucket and we carry it around with us. And then at some point in time, if we're unable to manage the things that are in that bucket, we pass it on to the next person, even though we're still alive. Maybe we're incapacitated temporarily or incapacitated permanently. We pass that bucket on to the next person that we've named. We call them a successor trustee, and that person picks up the bucket and they manage all of those things that are in it. They make sure our bills are paid. They make sure that our house has insurance and all of, that our debts are paid and people that we want to give money to are given money. All of the things that we would normally do with our stuff. That successor trustee can now pick up that bucket and run and do the things that they need to do to make sure that the things you can't do are taken care of. So during our lifetime, that is one of the things that a trust can do for us. It's important to notice that distinction that during your lifetime, the will doesn't really do anything for you, and the trust can. Now, again, if you have any questions about this, myestateplanmeeting.com, schedule an appointment. Excellent. Now, when it comes to the end of life, the trust basically will do the same things that the will do. It can, in a will you can set up trust for your heirs, in a trust you can set up trust for your heirs. In a will you can give money to charity, in a trust you can give money to charity. The difference about how they operate, though, after you've passed away, is that the will has to go to probate, has to be approved by the court. There's a court process. Probate, I've talked about it before, that the will has to operate under. The trust, on the other hand, can start operating the day after you pass away. There is no need for court intervention. It's privately administered. Basically, the same things happen for administration of a trust and a will, except for we take out that third party, we take out the court, we take out the need for filing fees, and we take out the fact that a will gets recorded or gets filed with the court, it becomes public record, everybody can see it. All of the subsequent documents get filed, the accountings, the receipts, the claims against the estate, all of that gets filed with the court so that really anybody walking down the street, if they so choose, could access those records and see what's in your will, see what kinds of things are in your estate because the accounting is filed, see who's getting things because they have filed receipts, or we've made a motion or a petition to the court to disperse assets to individuals. All of that sort of stuff will be public record. With the trust, it doesn't get filed with the court. It's held privately. Your successor trustee, oftentimes the same successor trustee that you would have had for incapacity, will look at the trust, follow the directions that you've given inside of that document. Just, pay your debts, distribute your assets pursuant to your wishes inside of your trust, and it all happens privately. So those are some of the fundamental differences about when a trust and a will are operative, when they can actually do something. Again, if you have any questions, do feel free to reach out to me by going to myestateplanmeeting.com, book a complimentary estate planning strategy session with me, and I will be happy to answer any of those questions and talk to you about your estate planning options. Again, my name is Don Rolfe, owner and founder of Northwest Legal Planning. If you like this video or podcast, however you're consuming this content, please click the like button, leave a comment. If you know somebody else that would benefit from this information, please do share it with them. And until next time, take care. Goodbye.